Alrighty, good evening everyone. We're going to go ahead and get started. Welcome to the Supreme Court Roundup. My name is Chloe Knox and I'm the Vice President for Speakers for UVA's Federalist Society chapter. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Tonight, our panelists are Julia Mahoney, Daniel Ortiz, and Jeffrey Harris. Professor Julia Mahoney teaches a variety of courses at UVA Law, including property, corporations, and feminism in the free market. She is a graduate of Yale Law School and joined UVA as a professor over 20 years ago after practicing in New York. Her scholarly articles discuss issues of land preservation, eminent domain, healthcare reform, and property rights and biological materials. Professor Dan Ortiz also teaches a variety of UVA courses, such as constitutional law, administrative law, electoral law, and civil procedure and legal theory. He is a graduate of Yale Law School, worked for then Judge Breyer on the First Circuit and Justice Powell on the U.S. Supreme Court. Professor Ortiz is director of UVA Law's Supreme Court Litigation Clinic. Jeff Harris is currently a partner at Constable McCarthy. He previously served as the Associate Administrator of the Office of Information and Regulatory Affairs at the White House, and before that was a partner at Bancroft as well as Kirkland & Ellis. Mr. Harris is a graduate of Harvard Law School and clerked for Judges Sintel and Silberman on the DC Circuit and Chief Justice Roberts on the Supreme Court. He has argued at all levels of federal and state courts, including the U.S. Supreme Court. Thank you so much to our panelists for joining us tonight. How the format is going to work is that Professor Mahoney will speak first, followed by Professor Ortiz, and then Mr. Harris. And while they are speaking, audience members can submit their questions one of two ways. You can either use the Q&A function at the bottom of your screen, and I will read those questions out loud, or you can raise your hand and I can unmute you while you are, so you can ask your question aloud during the Q&A portion. And with that, Professor Mahoney, I'm going to go ahead and turn it over to you.
All right, thank you so much. This evening, in the time that I have allotted, I'm going to be discussing 4 decisions that the Supreme Court handed down this past term. Maine Community Health Options, the United States, which concerns promises contained in the highly controversial Affordable Care Act passed in 2010 that the United States government would, under certain circumstances, make significant payments to health insurance companies. Then Trump v. Mazars, USA, which involves 4 subpoenas issued by 3 different committees of the United States House of Representatives. All these subpoenas sought information about the finances of the president and his affiliates, including some of his family members. Trump v. Vance, which arose out of an investigation launched by the New York County District Attorney's Office into business transactions that were said to be potential violations of New York state law. And finally, June Medical Services v. Russo, which concerns constitutional challenges to a recently enacted Louisiana law that heavily regulates the provision of abortion services. So first, the Maine Community Health Options case. This case attracted fairly little attention from the mainstream press, but I believe it may well be the most important, thinking about potential long-term consequences of the 4 cases that I am going to be discussing this evening. Maine Community Health Options marked a significant victory, at least on the surface, for 4 health insurance companies, all of which had sought money from the federal government for losses that those health insurance companies had incurred from participating in new insurance marketplaces that had been set up by the Affordable Care Act. The financial ramifications of the Supreme Court's decision are considerable because health insurance companies are going to be paid hundreds of millions, maybe even billions of dollars. But it's very important to note that the significance of this case extends far beyond the resolution of yet another quarrel that has arisen out of the Affordable Care Act. That is because at the heart of the dispute of the parties are hard questions about how and to what extent the United States government may bind and unbind itself from obligations to pay money in the future. Now, the Maine Community Health Options case is commonly known as the risk corridors case. And that is after a provision of the Affordable Care Act that sought to encourage insurers to offer policies on new health insurance exchanges set up pursuant to the Act. But insurers were understandably wary of offering these policies because they did not have a good grip on what their likely profits and losses would be. And so in the Affordable Care Act, there was inserted a provision known as the risk corridors provision, which were meant to cap, to put a ceiling and a floor on the financial obligations that insurers might have if they participated in these new exchanges. To allay these concerns, the Affordable Care Act set up a scheme under which the federal government would bear some of the downside and share in some of the upside in the first 3 years of the implementation of the Affordable Care Act, hence the term risk corridor. But, and this is a huge but, Congress did not appropriate any funds at the time of the passage of the Affordable Care Act to cover potential costs to the federal government of the so-called risk corridors program. And at the time of the passage of the Affordable Care Act, critics pointed out that the potential financial liability to the US government was uncapped. Surely there had to be some kind of limit. No, apparently not. In any event, the years passed. It took a while for the Affordable Care Act to be fully implemented. And in the meantime, the control of Congress changed. Congress had been in the hands of the Democrats, both the Senate and the House of Representatives at the time of the passage of the Affordable Care Act. But a few years later, when the risk corridors provision was being actually implemented, the House of Representatives was in the hands of the Republicans. They did not like the Affordable Care Act, and they decided that they would simply not appropriate any money for the payments to the insurance companies under the risk corridors program. Not surprisingly, the insurance companies were very angry and they sued. They said, it is in the text of the Affordable Care Act that we get money if we participate in this program. We participated in the risk corridors program. We have lost money. And now you, the House of Representatives, you are saying, ha, we don't have to pay you because we have not appropriated the money. The Supreme Court sided with the insurance companies and found that Congress had indeed created an obligation for the United States government, notwithstanding the decision of the US House of Representatives, which it is often says has the power of the purse, not to appropriate any money for the risk corridors payments. It is true, said Justice Sotomayor, writing for an 8-person majority of the Supreme Court, that the typical route to creating and satisfying a government obligation is to proceed in 4 steps. With the passage of an act, like the Affordable Care Act, that creates a, quote, program, agency, or function, followed by the passage of appropriations, of an act authorizing appropriations, followed by an enactment of the actual appropriation, and finally the incurrence of the relevant obligation by the government. But even though that's the norm, Congress has power to deviate from this pattern and create an obligation, in Justice Sotomayor's words, directly by statute, without also providing details about how it must be satisfied. Justice Sotomayor emphasized on several occasions that Congress could have, but did not, expressly repeal all or part of the Affordable Care Act. Now, this decision, even though 8-1, raises a lot of questions. The Supreme Court did not close the door on the idea of an implicit repeal of a statute or a portion of a statute, but it did seem to emphasize that in the ordinary course of events, any kind of stepping back would be through an express repeal of a statute. But the questions remain, because the United States government has, one can argue anyway, incurred an awful lot of obligations, made an awful lot of promises. Many, including me, have argued in print that there's a significant possibility that the United States government won't be able to meet all its promises. So in what circumstances can the US government step back, and what circumstances will it, as in the Maine Community Health Options case, be told that it must actually go forward and pay the money that it is said to have promised? Anyway, I would say that there are going to be other cases along these lines, particularly given the further deterioration of the US government's financial position in the wake of the COVID-19 pandemic. Now, on to our next case, Trump v. Mazars USA. This is a case that involves 4 subpoenas issued by 3 committees of the United States House of Representatives, all seeking financial information of the President of the United States and his affiliates. Why on earth would Congress want to have be seeking such information? Well, the claim has been that these committees are carrying out serious investigations and therefore need the material. One of the House committees is investigating possible violations of the Emoluments Clause. The other 2 committees are investigating possible foreign influence on United States democracy. And so the committees have decided they need this information. They've issued subpoenas. Not surprisingly, the president and others have pushed back hard and said this is ridiculous. This is just political theater. They're just trying to bother the president. Well, one might say, surely these quarrels between the president on the one hand and the House of Representatives seeking information on the other, surely these sorts of disputes have come up before in the history of the United States. Well, not exactly. It's not that there haven't been disputes between the House, which is seeking information, and the Senate too, between Congress, which is seeking information, and presidents who do not want to give information. But as Justice Roberts, in his opinion for the court, this was a 7-2 decision, kept pointing out, normally, or at least throughout United States history, quote, Congress and the president have maintained a tradition of negotiation and compromise without the involvement of the courts. Only with this present dispute have Congress and the president not been able to work out what sort of information the president is going to give Congress and under what terms. The fact that the president and Congress can't agree on what sorts of information they are going to provide seems to be irritating, and we can understand why Chief Justice Roberts, when he writes this majority opinion in Trump v. Mazars, can't you two, Congress and the president, can't you get along without involving the judicial branch? Well, no is the answer. They can't get along. The judicial branch now is involved. So what is the Supreme Court going to do about it? The Supreme Court notes that the approach of the House, or at least the approach that the House has urged on the courts, is to have the courts ignore that the subpoenas that they're issuing, these disputes that they're involved in, involve the President of the United States. And the lower courts largely followed the lead of the House of Representatives and, as Chief Justice Roberts put it, treated these cases much like any other, applying precedents that do not involve the president's papers directly. And Chief Justice Roberts' view of this is no, that is not going to cut it. The House's approach and the approach of the lower courts that followed the lead of the House of Representatives, quote, fails to take adequate account of the significant separation of powers issues raised by congressional subpoenas of information involving the president. And so the lower courts are going to have to take another look at this. Congressional subpoenas for the president's personal information implicate weighty concerns involving separation of powers. We have concluded, therefore, that in assessing whether a subpoena directed at the president's personal information is related to a genuine task of Congress, as opposed to simply being another way in which congressional powers can be weaponized for petty political gains, the courts are going to have to take very seriously these separation of powers concerns. They're going to have to carefully weigh whether the asserted legislative purpose warrants the, quote, significant step of involving the president and his papers. And the courts are supposed to take an active view and involve themselves in real oversight. Next case I will discuss also involves a fight over presidential information. This is the Trump v. Vance case. Trump and his attorneys in this case took a very aggressive litigation posture faced with the New York authorities trying to get in about Trump. Trump made out a claim that Article 2 and the Supremacy Clause categorically preclude, or at the very least require, a heightened standard for the issuance of a state criminal subpoena to a sitting president. This claim of absolute or close to it immunity was unlikely to fly, and very few observers thought that this could possibly be successful, and it wasn't. But that said, there was still a great deal of concern on the part of the court of the spectacle of the president being possibly harassed for potentially petty political purposes, rather than as the result of a good faith investigation. So although the Constitution does not entitle the executive to absolute immunity or a heightened standard, he is not going to be treated, says the Supreme Court in Trump v. Vance, like any other citizen. There is going to have to be some sort of careful examination of what sorts of standards need to be crafted in order to protect the presidency from from in effect harassment. So the disputes over Trump's finances continue, and stay tuned. We may well see more sensitive information, financial information, from Trump and his affiliates, but not anytime soon. Final case that I will be discussing is the June Medical Services case. The June Medical Services case, as I mentioned earlier, involves intense regulation of abortion on the part of the state of Louisiana. One thing that makes the June Medical Services case quite interesting is that the statutes under dispute in the June Medical Services case is almost identical to a Texas statute that had been deemed constitutionally infirm 4 years ago. And so what had changed? Why is it that abortion opponents thought they had a good chance of victory when the Supreme Court had, back in 2016, just 4 years ago, found that a almost identical Texas statute had amounted to unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion and are thus constitutionally invalid. In a nutshell, abortion opponents thought they might win because of personnel changes on the court. Justice Kennedy had retired, and Justice Roberts was in the minority in the Texas case. Surely, or maybe surely, he would side in this case for striking down the Louisiana law as unconstitutional. But no, Justice Roberts sided with the justices who thought this statute was unconstitutional, but he didn't change his mind about undue burdens. What he did was to concur in the judgment to add a fifth vote, thereby leading to the statute being struck down as constitutionally infirm. Justice Roberts' concurrence in the judgment was all about stare decisis. We decided a case pretty much identical to this one 4 years ago. And there are excellent prudential reasons, excellent institutional considerations, said Chief Justice Roberts in his concurrence in the judgment, for us not to reverse, not to in effect turn around. So Chief Justice Roberts' concurrence in the judgment is an opinion that is all about stability, all about the value of having predictability in the most important areas, some of the most sensitive areas of constitutional law. All right, with that, I will turn it over to my learned colleague, Professor Ortiz.
Thank you, Julia. It was really fun. Thank you, everyone. Hi, and thank you for the invitation. It's really a pleasure to be here, and it's so wonderful to see so many people coming out for a virtual discussion of law on such a beautiful Charlottesville day. Now, I'll be talking about three cases today. The first, Little Sisters of the Poor versus Pennsylvania, which was the Affordable Care Act contraceptive religious exemption case. Chafalo versus Washington, the faithless electors case, and McGirt versus Oklahoma, the case that decided that half the state of Oklahoma is an Indian reservation. Now, only Chafalo was a constitutional case. Now, first, Little Sisters. It was one of the many challenges to the reach of the Affordable Care Act. And as probably people know from prior iterations of this case, Hobby Lobby and maybe Zubik, the ACA requires most employers to provide female employees with health insurance that covers at no cost, with no cost sharing, certain forms of contraception. Now, the federal government, nearly from the beginning, as a matter of regulation, exempted churches from the requirement and provided religious nonprofits an opt-out. Under the opt-out, they had to provide notification to the insurer that they were opposed for religious reasons to the coverage. And then the insurance company basically had to provide it through a form of cross-subsidization at no cost to the religious nonprofit itself. Now, in Hobby Lobby, which was decided in 2014, the court held that the federal government had to extend the opt-out to a corporation that was owned by a family that had religious objections to the insurance requirement. In 2016, though, the case came back, or the issue came back to the court when religious nonprofits challenged the opt-out provision itself. They argued that by notifying the insurers that they objected to the coverage, and then the insurers providing the coverage to the employees, even if at no cost to the religious institution itself, that they were made complicit in something that was against their religious beliefs. So it was a kind of complicity challenge to it. Now, this case came up after Justice Scalia's death and before Justice Gorsuch's confirmation. The court had 8 members and was susceptible to a tie. And probably for that reason, the court sent the case back to the lower courts without resolving the issue. The court basically said, let's encourage the parties should consider themselves encouraged to find an accommodation that both sides can live with. And after some negotiations, the parties tried that and nothing seemed to work out. Then after Justice Gorsuch's confirmation, the court took up the issue again. This time, at full membership, they could presumably decide it. Now, what's really interesting about the case is that it has the culture wars written all over it. You've got sex on the one side and religion on the other, right? And from that comes all the excitement and interest in the case. The opinion, however, turned out to be a pretty humdrum exercise in administrative law. The court said that the statutory words that employers had to provide insurance as provided for by the agency meant that the agency had power to make exceptions. And it could have been any kind of standard issue in administrative law. The court also rejected the state's arguments that the exemption creating process, which relied on interim final rules rather than ordinary notice and comment rulemaking, was okay under the circumstances. And again, that wasn't really a big deal in administrative law. Now, I can feel even virtually, even though I can't see you, that your eyes are glazing over at this point. But I hate to tell you, this stuff is heart pounding for a true administrative lawyer. Now, and I think that explains why two of the court's liberals, Justices Breyer and Kagan, concurred in the opinion. They are the leading administrative law types on the court right now, and both were very prominent academics at Harvard who taught administrative law. And of course, they came in and concurred, but they did so largely on a different set of ad law doctrines, ones that allow for the court to defer to the agencies. That's a little bit more controversial these days, but still it's kind of heartland administrative law, steered away from both sex and religion. So whatever heat was left in the case at this point came from Justice Alito's concurrence, which was joined by Justice Gorsuch, and Justice Ginsburg's dissent, which was joined by Justice Sotomayor. The former opinion, Justice Alito's, furnished the religion, and the latter, Justice Ginsburg, furnished the sex. So you can sort of see that, you can still see that debate in the background among the sides. Now, Justice Alito thought that RFRA, the Religious Freedom Restoration Act, required this accommodation, And Ginsburg thought that the agency could accommodate religion, but not when doing so had, in her view, hard effects on third parties. Interestingly, the court's opinion didn't settle the bottom line issue. As Justice Kagan pointed out, there's another round of ad law to go in the case. It was returned to the lower courts, and they will have to consider whether the exceptions, particular contours, make it arbitrary and capricious and therefore invalid under the Administrative Procedure Act. But again, this is going to be this kind of garden variety ad law. But you should expect it to come up again at some point, maybe not this particular case, but another case on the same issue. If you want something to compare it to from the past, you might think of the census case from last term, concerned a really high profile, really big political issue. But then again, it came down in the end to garden variety administrative law. That doesn't make it any less exciting to law nerds like me, I'm afraid. But the implications are liable to be completely misunderstood by ordinary folk who follow the court. Now, next up is Chafalo, which is the faithless elector case. They concerned whether members of the Electoral College were basically free agents who could do what they wanted to, or whether they could be penalized by the state that appointed them for violating their pledge to vote for their party's nominee. The faithless electors came from Washington and Colorado. The ones from Washington cases are more important. Those electors were fined $1,000 apiece for voting for Colin Powell for president when they met, rather than for Hillary Clinton, whom they had been pledged to. Now, the battle really was an interesting one, conceptually, sort of political theory, if not so much in the law, is between the framers' conception of the electors' independence and the rise of the political parties, which the framers certainly didn't foresee. The rise of political parties was one of the great, you might say, original misunderstandings of the framers. And of course, this year's presidential election was in the background of all of this. At oral argument in particular, you heard justices raising questions about the fear of chaos, things not becoming unclear, a rerun of Bush versus Gore, that sort of thing. Now, in the end, all 9 justices thought the penalties were fine. I think most commentators, after listening to the oral argument, thought that it would be at least a divided case and maybe a closely divided one. But in the end, that didn't happen. Justice Kagan wrote a very fun opinion. I encourage you to read it. It's clear it's her style, referencing, among other things, Veep and the musical Hamilton on the way to getting to the court's decision. And everyone joined it except Justice Thomas, who concurred only in the judgment. He wrote an opinion which made 2 separate arguments. I'll talk about them just a little bit. And Justice Gorsuch joined the second one, not the first. Now, according to the court, it was a pretty simple Article 2, Section 1 issue. That's the provision in the Constitution that allows the states or requires the states to appoint electors. And the question was, did that provision, which is basically about the only place with the 12th Amendment, give the states, that provision giving the states the responsibility to appoint electors, prevent them from sanctioning faithless ones? And Kagan said, the text is basically silent, and that controls. We don't need to go any further than that. The electors, had said that the words elector, vote, and ballot, which was secret, secret ballot, meant that they were free agents. But Kagan said, well, that's really reading a little bit too much into those words. And then she also rejected the electors' arguments that went to history and liquidation through historical practice. As she put it, the history going the electors' way is one of anomalies only. Sure, there's some history there, but it was the exception rather than the rule. So I said Justice Thomas would have reached the same result, but through different means. He put up two arguments. The first was that, well, this wasn't a matter of really interpreting Article 2, Section 1 at all. It was just a matter of inherent state power. And the states, nothing spoke to it, so it's the states to do. And then he said, he made a basically a 10th Amendment argument, and it was the second that Justice Gorsuch joined. Now, finally, there's the big case of McGirt versus Oklahoma. This is a case that absolutely everyone was waiting for, at least if you live in Tulsa or the eastern half of Oklahoma. McGirt was an enrolled member of the Creek tribe, and he was convicted in state court of 3 serious sexual offenses. He argued during post-conviction relief proceedings that the crimes under the Major Crimes Act, which is a federal statute, he could be prosecuted only in federal or in tribal court, not in state court. And in a 5-4 opinion written by Justice Gorsuch, the court basically agreed. I think this is probably one of the more surprising cases of the term. People had said, well, people noticed that generally Native Americans aren't very successful in claims like this before the court. And here, since it concerned about half the state of Oklahoma, I think a lot of people thought by hook or by crook, the court would find that Congress had somehow disestablished the reservation. The case is less interesting in the end for its holding, I think, than for what it says about Justice Gorsuch. The case pitted 2 views of the law against one another. Do we require that Congress had clearly disestablished an Indian reservation before we say that the Major Crimes Act does not apply? Or do we look to practical implications and historical evolution on the ground for guidance in getting to our decision? And Justice Gorsuch very forcefully said, you look to the law and you don't look at all that other stuff. Historical practice really doesn't matter unless the law, maybe some when the law itself is not very clear. But here, things were pretty clear. Congress had never expressly disestablished the reservation. And he really broke from the other conservatives who took a much more flexible historical approach, looking at the actors' assumptions, states' assumptions, what kind of power Oklahoma had, kind of power, what the federal government's view of things, and the fact he wasn't daunted by the fact that many Oklahoma criminal convictions would be thrown into question by this. He basically said the law is the law. Now, it's also interesting that Gorsuch, the only justice coming from the West. Now, I know many of you were saying Justice Breyer grew up in San Francisco, but that doesn't really count. Gorsuch was, sympathetic, or at least open to Native American claims. And I think that's really interesting and may have some traction in Indian law cases going forward. It's just going to take some time. There typically aren't that many of them. But I say, but as I said, the really interesting thing is his kind of distinctive approach towards statutory interpretation. And it may be, we saw another example of this term, which Jeff is going to cover in Bostock when he discusses Bostock. Interestingly, in Bostock, the Chief Justice was on his side. Here, the Chief wrote the dissent. So it's Justice Gorsuch does really seem to be a little bit of a separate character, at least among the conservatives at this point. So, turn it over to you, Jeff. And I hope I didn't preempt you too much. Sorry, Jeff, at least for me, you're muted. I don't know, they didn't turn.
There we go, sorry. Yeah, then with that transition, why don't we start right away with Bostock. So Bostock, which I argued unsuccessfully, was one of 3 consolidated cases addressing what really is a fairly discrete legal issue, which is Title VII of the Civil Rights Act of 1964 prohibits discrimination because of sex. And so the question is, does that include sexual orientation and gender identity, or is it just discrimination of men against women, or vice versa? So a 6-3 majority of the court said that that discrimination because of sex does include sexual orientation and gender identity. The majority seemed to candidly think it was an easy case. The analysis was largely based on text, and it really set this up as sort of a simple comparator. They said, for example, take an employee who's attracted to men. If an employer fires a man attracted to men but wouldn't fire a woman attracted to men, that's discrimination because of sex. QED, game over. And so, the dissents, which were, there was one with Alito and Thomas, and then Kavanaugh wrote a separate dissent. They were pretty harshly worded. The Alito dissent in particular accused the majority of engaging in legislation. And I think, as Professor Ortiz said, I think some of this does boil down to, do we look at the literal words, which is very much what the majority was doing, versus sort of the ordinary usage. And Alito, was making the point in his dissent that it would have been inconceivable to someone in 1964 that discrimination because of sex might have included discrimination because of sexual orientation or gender identity, emphasizing that these are just simply different traits. And although sex may be related to sexual orientation and gender identity, no one would say they're the same. So I think, the legal issues, I think, are fairly well teed up by the opinions. I think the one bracketing any merits issues, I at least find a little frustrating. I think as Justice Alito noted in an appendix to his opinion, there are just tons and tons and tons of federal and state and local and municipal and county laws that use almost exactly the same words. And I think the majority basically just said in one paragraph, we'll save all of those for another time. We don't need to deal with those. And we'll consider things like religious objections. We'll consider other contexts. I think the issue is by no means resolved once and for all. I mean, take something like Title IX. You can very much have claims of sex discrimination on both sides. So there are some of these issues percolating, brought by kind of multiple different angles of transgender athletes in sports. And I think some of these cases are brought by competitors who are saying, I faced sex discrimination because I'm a biological female and you forced me to compete against people who are biologically male and identify as female, whereas other schools are being sued from sort of the opposite angle, saying you've discriminated against me based on transgender status if you don't allow me to compete in the sport, based on the gender I identify with. So, I think the majority seem to think that a lot of these were very clean, just do the comparator, change the gender, QED, we solve it all once and for all. And I think there's going to be considerably more litigation. And then, maybe in the Q&A we can get to, there's a case called Fulton, which is teed up for next year, which could address, some of these very, very long-standing open questions of how religious exercise defenses interact with civil rights laws. So that's Bostock. Turning to DACA, also I'll note there are many terms that are sort of nothing burgers. This was a pretty big one. I mean, between the president versus the House, DACA, religion, sexual orientation, separation of powers, on and on and on. This was a pretty substantial term. So we're just scratching the surface here. So DACA, to understand that case, you have to go back to 2012 and sort of how the whole program came into being. So in 2012, by a 3-page memo from the Department of Homeland Security, the Obama administration announced 2 pretty major policy initiatives on immigration. So for people who met certain criteria, such as being brought into the US as a child, having a clean criminal record, being in school, you get 2 big benefits. The first is the administration will not initiate removal proceedings, so they won't try to deport you. And second, they would affirmatively give you authorizations that would enable you to work legally in the United States. Now, this was not done through notice and comment rulemaking. And one of the reasons it was controversial is the program was adopted very shortly after the administration had failed to enact legislation that would have done, pretty much a lot of the same things. So then we fast forward to 2014. The administration expands the program. So the Obama administration adds a new program called DAPA, which is for the parents of DACA recipients, and makes some other changes to the eligibility criteria. The Fifth Circuit enjoined the expansion, but not the original program. And the Supreme Court affirmed that decision 4-4 in the term where Justice Scalia passed away. So when cases split 4-4, there's no opinion. So the Fifth Circuit opinion enjoining DACA is affirmed, but with no opinion about its reasoning. So then we fast forward to 2017. The Trump administration comes in and has a very different view of a lot of these issues. And the Trump administration attempts to rescind DACA solely on the ground that they believed it was illegal. So just like the original 3-page memo, there wasn't a ton of analysis, not much explanation. It cited the Fifth Circuit opinion, and it said, we think DACA is unlawful for basically the same reasons that the Fifth Circuit said about DAPA. That's challenged by many, many parties, and the Supreme Court nonetheless reversed that rescission, and in a 5-4 opinion by the Chief Justice, held that the rescission violated the Administrative Procedure Act. So the core of the Chief's opinion was, he said it wasn't enough to just cite the Fifth Circuit opinion. And so the Fifth Circuit opinion really focused heavily on the work authorization piece. So it pretty comprehensively explained why that court found it unlawful to give benefits or work authorization to people in the DAPA program. But the Chief said the administration did not do enough to explain why they were rescinding the other piece, which was the enforcement forbearance piece. And so, for example, the Chief said DHS should have considered alternatives, such as maybe eliminating the work benefits or work authorizations while still keeping in place the forbearance from deportation. The majority also said that the Homeland Security Department failed to address legitimate reliance interests, and those in the program were people who planned jobs in school and families and everything based on being in the program. And the court said that the administration did not give enough weight to those things. The dissent said, this was all unlawful. It said that it, quote, conferred lawful presence on an entire class of aliens in the absence of either statutory authority or notice and comment. So the dissent would have gone, which was by Alito, Thomas, Gorsuch, and Kavanaugh, would have affirmed the administration's rationale. So my takeaways on the DACA opinion, people can debate in good faith and will continue to debate the merits or the policy wisdom of the program, but I think it's really troubling as a matter of administrative law. So the core holding was that DHS didn't explain well enough why it thought the forbearance piece should be rescinded as opposed to the benefits and work eligibility. But I think that's exactly backwards. The forbearance piece is the piece that seems most discretionary because it goes directly to the executive's ability and power to enforce the law and faithfully execute the law. So that doesn't strike me as an APA issue. So for example, if the Obama administration, let's say, had a policy where they just didn't, as a matter of discretion, prosecute certain low-level drug offenses, but then the Trump administration came in and started prosecuting those offenses, no one would say that they owed some explanation or some duty under the APA to explain why they were not enforcing the law a certain way. That's just enforcement discretion. And so I guess there's a certain, yes, there wasn't much explanation of that, but it also seems odd to say that the decision largely turned on a failure to adequately explain why the administration was doing the thing that's the most discretionary in all of this. And so, the last thing I'll say about DACA is I also think there's an asymmetry in the administrative process there. Justice Scalia, before his passing, used to write about the ossification of administrative law, where once something is in, it kind of gets stuck and then can never really go away. So DACA, again, was a very hotly contested program affecting millions of people that was created by a 3-page memo from DHS. There was no statute, there was no notice and comment, there was no rulemaking, there was no regulation. And then it resulted in special status and benefits being given to millions of people who then used it and relied on it. And so then when the next administration decides to rescind it, also through the proverbial 3-page memo, now there's all of a sudden a heightened burden of explanation in all of this, and had to, the Supreme Court expected all this additional work. And so it seems it seems asymmetrical that this massive program could be created based on the thinnest of reeds of administrative law, but then not rescinded and sort of locked in just by inertia. So I at least think it rewards what was a very dubious use of executive power in the first place, and I think it creates terrible incentives for outgoing administrations, because it suggests that if you just put enough policies out there that people will rely on and worry about the legality later, that then your successor is bound to have some heightened APA duty to explain it before making any modifications or rescission. So I think it makes it harder for elections to have consequences in administrative agencies. So the last case I will cover before talking about some of the non-case stuff is SALA law, which is about the constitutionality of the Consumer Financial Protection Bureau's single head structure. And I'll just note one anecdote on the CFPB. So when I was working at OIRA, which is the office in the White House OMB that does regulatory review, the office is on 17th Street, and literally the OIRA office looks out across the street on the building of the CFPB. And we were there at the very beginning when, I don't know if folks remember this, the director, Richard Cordray, who was an Obama appointee, refused to leave. And so I think he held over for about a year. And so we just had some running jokes about how, you had the regulatory review office and that, there was this agency that nominally is part of the executive branch that was across the street, and no one really had any idea what they were doing or who they were reporting to or what policies they were making. So just sort of independent agencies in practice, but that's a digression. The key issue in SALA law, there's long been a sort of uneasy tension in the separation of powers doctrine about presidential power. So Myers versus United States is a landmark 1926 opinion by Chief Justice Taft that says removal runs with appointment, and the president has to be able to remove officers to ensure that the laws are being faithfully executed. But then you have a case called Humphrey's Executor from 1935, which says that Congress can create independent agencies that are exercising what the court called quasi-executive or quasi-legislative and quasi-judicial functions. And so pretty much ever since, there's been a push and pull between these two decisions. They candidly don't sit very easily with one another, and each has had high and low moments in the following decades. So SALA law is a 5-4 opinion by the chief, is a major win for the Myers camp. Again, the CFPB is run by a single head who is insulated from removal except for cause. And the CFPB is uniquely insulated from political control because it doesn't rely on appropriations, but instead on fees charged by the Fed. So even constraints about agency funding or sort of power of the purse don't apply to the CFPB. So the majority holds that the CFPB's structure is unconstitutional because the director must be removable by the president at will. For all intents and purposes, the court limited Humphrey's Executor to multi-member agencies such as the FCC, SEC, FERC, and some of those. But even in doing that, the chief's opinion takes a lot of shots at Humphrey's Executor and says that its reasoning, quote, has not withstood the test of time. Justices Thomas and Gorsuch would have overruled Humphreys altogether. So, in terms of that issue, this is a pretty conclusive blow in favor of administrative agencies being accountable to the president, and sort of a blow against, insulation, for better or worse, on its policy wisdom. So my takeaways quickly on SALA law. This is a big deal for presidential power. The court did not pass on multi-member independent agencies because those weren't before the court. But I do think it's a pretty significant shot across the bow that Humphrey is an aberration and is at the very least not going to be extended. The last thing I'll say about this is I think SALA law really shows some of the intellectual influence of Justice Kavanaugh on separation of powers principles. So the majority opinion in SALA law tracks extremely closely, and in some places almost verbatim, an opinion Justice Kavanaugh wrote on the DC Circuit in a case called PHH. And then it also relies heavily on the Supreme Court's earlier decision in Free Enterprise Fund, which was also based heavily on a Kavanaugh DC Circuit opinion. So although the chief wrote it, I think it really incorporates a ton of the legwork that Justice then Judge Kavanaugh has done on these separation of powers principles over the years. So the last thing I will cover in my last few minutes is the quote unquote shadow docket, which refers to the non-merits briefed and argued cases. So these are things like stays, orders, injunctions, all of the stuff that comes up to the court outside the context of a briefed and argued case. So two big buckets on those, capital cases and elections. In capital cases, there were a number of contested fights this year, some about the federal government had resumed executions for the first time in many years, and several different district judges had enjoined those or issued stays or issued last minute injunctions. And I think almost uniformly, if not uniformly, the court lifted all of those stays. So I think whereas in capital case, I think a big part of the litigation strategy often involved last minute, literally the day of the execution, there being big contested stay fights. I think the court has sent a pretty unequivocal signal that it wants out of that business, that if these issues are being litigated, they need to be litigated in the ordinary course before getting there, and that it's just not willing to jump into these last minute 11th hour stay fights to jump in and stop execution. So I think the court has sent a very strong signal to the lower courts that they need to be taking a restrained view of the judicial power on some of these things. Now, elections, kind of a similar theme. So these have been coming up again and again. So start with Wisconsin. A couple months ago, a district judge ordered Wisconsin to allow and count certain mail-in ballots that were collected after the deadline. And the Supreme Court, by a 5-4 vote, granted a stay to stop that and said, the district court had no authority to issue this relief that even the plaintiff hadn't requested. Then there's one, Alabama. Another district court prohibited Alabama from enforcing its law requiring certain matches on signatures for absentee ballots. District court enjoined it. Once again, Supreme Court lifted the stay. It came up in Florida. So there's a huge case pending right now in the 11th Circuit on a challenge to Florida's law in re-enfranchising felons. So Florida says felons, in order to have your voting rights restored, you have to meet all terms of your sentence, including any fines or restitution. And that law is being challenged on a number of grounds. But the district court enjoined it. The 11th Circuit lifted the stay, and some plaintiffs asked the Supreme Court to reinstate the stay, and the Supreme Court declined to do that, so allowed the law to go into force. So when you read these cases together, I think the court is once again sending a very clear signal of, district judges should be extremely reluctant to jump into an election. There's a case called Purcell from about 15 years ago, which is an opinion by the chief. It's just a little per curiam opinion, or I guess, I'm not sure if it's signed by the chief or per curiam, but it gets cited all the time for the proposition that, as you get closer to an election, courts should not be jumping in to issue these injunctions that are rewriting lots of election procedures. So I think these cases, the tenor and theme of them seems pretty clear, which is that the court is not going to want district judges to be jumping in and giving themselves the power to be rewriting election laws in the face of COVID or anything else. Because, you know, candidly, I think it's the chief's nightmare to have the court involved in any capacity in any, you know, consequential disputed issues as we get closer to the election. He may not have have a choice because the suits are going to keep coming. But I think the message that's coming out of some of these shadow docket cases is the Supreme Court is sending a pretty clear signal to district judges that it's got to be up to elected officials to be, you know, to be making the first, you know, determinations about how to run their elections and not district judges. So anyway, so I will stop there.
Great, we're gonna go ahead and move into our Q&A portion. Professor Ortiz, I believe you had a question for Jeff.
Hey, Jeff, I just, Joan Skupik, as you probably know, wrote a series of really interesting articles about what was going on behind the scenes in the court this year. And she spent at least one of them, maybe two, talking about Bostock. And I was wondering if you had any thoughts on the probability of that backstory, because if true, is sort of surprising. And also, if you could share your thoughts on the possible implications of the approach taken in Bostock if it were expanded to race.
Sure. So I think, you know, and I guess Biskupik, I think she said that the chief and Gorsuch had voted the way they voted from the start. Like, I know some of the cases, including June, and I think some of the presidential case, I think she reported that there was flipping back and forth. I mean, you know, some people were reporting shortly after the argument that Gorsuch seemed skeptical. I didn't get that so much. I mean, you know, I thought he asked fair questions of both sides. You know, no, I don't have anything beyond the article to add on that. But you know, and I assume on race, you're asking the question of whether that would sort of what that would mean for the writing on the wall of affirmative action and things like that.
Yeah, that type of stuff.
Yeah, I mean, in the race, you know, the analogies to race are super interesting because, again, you know, the plaintiffs in the case are actually the ones who often invoke race, because the plaintiffs want to draw the analogy to Loving versus Virginia and say, look, in Loving versus Virginia, it's no defense to say that you treat everyone equally, because nobody can marry someone of the opposite race, just as, you know, just like a white person can't marry a non-white person, a non-white person can't marry a white person. And so, you know, I think the response that, you know, the side I was arguing said was, it's actually, in the context of race, it's race all the way down, whereas in the context of sexual orientation or gender identity, there are these independent characteristics that are not sex, which again may have some connection to sex, but nobody would say they're the same thing. So no, I mean, I think this court, I mean, certainly the chief has never ever taken kindly to race-based decision making. I think that goes back to some of his earliest opinions on the court and parents involved, and some others. So, you know, I never try to ascribe too much sort of you know, long-term planning in the opinions, but it does seem like some of the reasoning, at least if you're going to do this analysis, I'm not sure how you could, at least in the employment context, justify any sort of race-conscious decision-making. Although I guess, you know, again, the court reserved all the questions about things like universities. You know, Title VI is the anti-discrimination law that applies to universities. And so would this interpretation under Title VI, you know, threaten universities that use affirmative action policies? I don't know, but I'm sure it'll be litigated.
Thanks.
Great. Professor Mahoney, the first question is for you, but all the panelists can chime in, of course. Can you speak more to the status of abortion law after June Medical? It seems that Justice Roberts wants to move back to the Casey test, while the plurality kept the Hellerstedt test. Is there any indication as to which test is the law?
Great question. If I had more time, I would have mentioned the aftermath of June Medical. There are a number of cases now in the lower courts that are trying to take advantage of the potential daylight between the four-member plurality by Justice Breyer, opinion by Justice Breyer and Justice Roberts' concurrence in the judgment. So I would simply say to that, stay tuned. I'm mildly skeptical that we'll see significant doctrinal shifts, at least not until we see significant shifts in the hearts and minds of the electorate. But as I say, stay tuned. Other comments? Jeff, you would have thought about June Medical.
Yeah, I mean, I think it's, the chief's opinion in that is really fascinating. I mean, so I actually do think it moved the law in the direction of the states. I mean, I think the two big innovations of the Texas case, the Hellerstedt Whole Women's Health case, were two things. Justice Breyer said that in abortion cases, there should basically be no deference to legislatures and lots of deference to district courts. Then that sentence ended with a period without citing anything. He just said that, which I think was sort of astonishing. And then the other big innovation was the court pretty explicitly saying you have to balance benefits and burdens. And the couple, the reason why that's odd, I mean, you think, well, you always balance benefits and burdens. How do you not do that? Except, in the abortion context, a lot of the benefits turn on things like informed consent, or, a lot of the laws at issue in Casey are things like, waiting periods, or, you have to get counseling from a doctor. You have to, they're designed to promote informed consent and deliberation. And so how does a court weigh the value of making someone wait 24 hours before getting an abortion against any burden caused by that? And to quote Justice Scalia's famous line, that's like asking, whether a rock is heavier than a line is long. And so the chief pretty significantly put an end to that. And he said, when you're looking at abortion laws, you look at the burden. Casey talks about substantial obstacle. And so the test, which he, to be clear, did not endorse, although he applied it, is he said you have to look at, is this keeping people from getting abortions without doing some amorphous inquiry into the benefits? And so, for me, I think those aspects of whole women's health were completely new and pretty hard to justify. And I think the chief, maybe as the price of his vote to strike down the Louisiana law, or I guess, he was by himself, so nobody else joined the opinion. But there's no question that in striking down the law, he certainly really looks like he's moving the law away from whole women's health and at least back towards Casey.
And you're going to get a lot of people trying to litigate in that space, and almost immediately you've already gotten them.
Yes, we're already seeing a spate of cases litigating exactly in that space. So.
Great. Our next question, speaking of Chief Justice Roberts, is from Ryan Kurdiak. He asks, is there anything to be gleaned ideologically from this term where Chief Justice Roberts has, in effect, become center of the court? That's open for anyone.
I mean, I'll take it. I mean, center is sort of, center is always a sort of a loaded term. I mean, I think, in cases like, and we didn't even bring up, Espinoza was another religion case about the constitutionality of Montana's prohibition on religious schools getting certain aid. In that case, in SELA law, I mean, the chief is still very, very capable of writing, strong, full opinions. And so I mean, some of these things I do think he has a discomfort. Maybe you see it in cases like the census case and the DACA case. I mean, he seems to have some discomfort with, some of the administrative law type things he's reviewing. but it's hard to see. I don't know. Center is still, I guess he's still the median, but I don't view him as sort of, historically like, trying to split the difference or balance or do things like that so much as, maybe his votes aren't always as predictable, but he still seems to want to get to, strong 5-4 majorities in some cases. So.
Okay, our next question is, another big term and mum's still the word on nationwide injunctions from the court. How likely are we to see the legal question of the permissibility of nationwide injunctions come before the court in the next term or two, especially given that multiple justices, Gorsuch, Thomas, and Ginsburg, have now staked out their positions on the legality of such injunctions? And is that an issue that you see as likely to break down along traditional ideological lines?
Start that one. Oh.
We can hear you.
Oh, okay, sorry. I think it may break down on traditional lines. It's going to depend upon which party is in power, and you're going to get people taking possibly inconsistent positions depending upon whose ox is gored. It's really interesting to me as an academic. There really wasn't an awful lot of scholarship in this area, and just now you're beginning to see the beginning of it, especially historical stuff. So I'd hope whatever the court does, that it probably waits a little bit just to see where that scholarship leads, and what kind of criticism it gets and all that. And the scholarship isn't monolithic; it's sort of conflicted at this point. But it part of this argument really does concern historical principle, and it would be a pity for the court to go too far without having the benefit of all that.
I at least eagerly await the whiplash from both the right and the left trying to switch positions. When in 6 months or 4 years, if there's a different administration, and everyone, all of a sudden the ACLU says that district judges have no power to do anything, and groups on the right are bringing suit in Lexington, Kentucky, and Waco, Texas to seek nationwide injunctions. So I hope everyone's a little more principled than that, but we'll see.
Okay, our next question is, Justice Gorsuch got a lot of attention this term. Could the panelists explain how they think Justice Gorsuch's version of textualism originalism are distinct from the other conservatives? Some have compared his libertarian streak to Justice Scalia. Do you think that is an apt comparison?
Well, I think that on criminal procedure matters, he does seem a little bit closer to Scalia in many ways than to the other current conservatives. I don't know that I would generalize much beyond that. He also has indicated that he might have a very distinctive or somewhat distinctive view of statutory interpretation, but I think actually we haven't seen enough yet to really know that. And this isn't to say that Bostock was just, in his view, a sport, but I think you actually need to see him taking on more of these kinds of hard statutory interpretation cases and seeing where he really ends up and how far out of line, let's say, the other conservatives he really is.
I agree with what Professor Ortiz just said. I would just add that although it's early days, so far Justice Gorsuch does seem to show more of an inclination to try to build bridges to other justices, particularly justices on the left, and to perhaps have ambitions of being part of a crafting of jurisprudence that will be more protective of personal liberties. But we'll see.
Great. I really like this next question. It says, what are your thoughts on the question asking protocol the court adopted during telephone arguments? Do you think that the justices or advocates would prefer that the court kept that format even after in-person arguments resume?
Well, there's one thing about it that they certainly would like. We've heard much more from Justice Thomas during these last few months than we've ever heard, I think, in the rest of his career on the court. And his voice is very distinctive and at times really interesting. And I think everyone appreciates that. And so that's why I don't know whether anyone, the people would want to adhere to this protocol. That's one very nice thing about it. It seems to have released the inner justice.
Yes, I'd like very much to hear the perspectives of my fellow panelists. It does seem to me that there's been a tendency to get to the heart of things faster, and that there has been less posturing. So for me, this has been a welcome change. But I'm curious, Jeff, do you think I'm right?
Yeah, I mean, I do think there's a little bit, I couldn't agree more about Justice Thomas. And I think, in fact, like his questions often, I think in some of the Trump tax return cases in particular, I think his questions often, being the second to talk after the chief, I think his questions often really helped frame it. So I couldn't agree more that him being more involved is a good thing. It does seem a little bit stilted. I think there's a little bit, I think it's very good that it, it does force them to be much more focused. I do think one thing that struck me about the telephonic arguments is every question is much more sort of to the heart of things. There's just less room for tangents. There's less room for hectoring. There's less room for really trying to ask 5 follow-ups if a justice isn't happy with an advocate's answer. And so it has been more focused. I do think you lose some of the other thing you seem to be losing are some of the friendly questions. I mean, you've seen this of both sides. Alito is very good at that on the right side of the court, and Kagan is very good at that on the left side of the court, where if an advocate seems to be floundering, they'll come in with sort of a softball or helpful question. You lose a little bit of that. So I don't know, it's a little more stilted. I think the flow of them seems a little different. I don't know, like everything, it has pros and cons. I think it's interesting, despite arguments starting in just a few weeks. I don't think, as far as I know, they've announced what they're planning to do for October yet. So I don't think it is at all out of the question that they would try to do some, very limited. I assume there would be no spectators, but even if it's just, socially distant justices and advocates, who knows? But I don't think they've officially announced their plans for October yet.
Well, great. I think that is all the time that we have for this evening, but I wanted to thank our panelists so much for joining us and for giving us your time. We really appreciate it. For our audience members, just so you're aware, our next event is next Tuesday, the 15th at 6 p.m. and it is on elections in the age of a pandemic. And we will have Professor Gilbert from UVA, as well as Scott Keller and Christian Adams speaking at that event. So we look forward to seeing you next week. And again, thank you so much to our panelists.
Thank you.
Thank you all.